Hello, this is Ms. Julu Adhikari. We are doing a presentation on the topic Great China Metal Industries Company Limited versus Malaysia International Shipping Co. Well, we are four members in the group, and my friend Lakmal, Narayan, Amber, and myself. So we are going to talk some issues, some arguments, some facts about this topic. And the introduction part I want to do is by my friend Narayan Paudel. So off to you, Narayan.
Okay, thank you, Zunu Adhikari. This is the case about, as he says, it's a case regarding the ship which was collapsed in the sea while carrying the goods from Australia to Malaysia. The case was held in the Australian court, and what the court will give the justifications regarding this case. The vessel owner who was claiming the compensation on this case, and the Great China Metal Industries who was not willing to give the compensation. This is all the case on which the court has to give their judgment. The court will certainly see the issues of international legal aspects and the similar type of situation in other countries. Also, the court will also look at the different aspects of this case, whether this was negligence from the cargo owner or it was not the negligence. So it is the introduction part. Now I would like to pass this to my friend Lakman, who will say briefly about the facts.
Actually, I'm going to explain about the facts. Like as my friend Narayan, he said, there was a shipping company, and they just carrying the stuff to the Malaysia, and while they carrying stuff to the Malaysia, their route was going towards from Australia to Malaysia, like from the Sydney harbour through the Melbourne to the Malaysia, towards to the Malaysia. And then when they going through the Sydney, there was a the bar strait, then they in Melbourne they got while they crossing the ship, due to the severe weather condition, they got they got damaged their all cargos, and it caused the injuries, and they lost their all the containers, and then due to the severe weather condition, then what actually happened was that vessel owner, whoever the cargo ship owned that company, then they try to they thought it's not part of the negligence, and then they try to claim it from the higher court, because it's part of the weather condition, and the weather condition happened in the Melbourne. Then they got it got place, and they got it's they able to mention it in the Australian bridge, in the Melbourne, and then they appealed it from the High Court, and then what actually finding of the court, the plaintiff was actually the judge made the possibility of the weather and the weather forecast and the severe weather condition, they are they able to claim it. So that's what basically happened in the facts, and because of the severe weather condition, judge they able to claim it true. Thank you.
Thank you, Lakmal. So as you talked about some facts arose during the Great China Industry and Malaysian international shipping faced. So I'm going to talk about what sort of conflicts and what sort of arguments was made during that time, and what sort of even the questions arose. So as the defense was taken up by the court, which regarding perils of the sea, that was discussed in widely in the case of shipping Gulf of India Chemical Company. The another question was when a vessel can be considered to be unseaworthy. Is it probable to believe that a vessel should have the basic potential to encounter the ordinary perils of the sea or not? In the case of Kopitov v. Wilson, it was held by the court that the carrier of the ship has to provide vessels which are fit to undergo the perils of the sea, and also encounters the risks that are incidental in the course of voyage. The same view was taken in the case of McFadden as well. And McFadden and also the Blue Star Line, both were held that the degree of any fitness shall flow from the prudence of the owner and the kind of ship he provides during the voyage. Therefore, the underlying meaning of the present cases is that it is essential to prove the vessel was free from all circumstances and it was fixed to undertake the voyage and have the basic parameters to encounter any injury that might arise in the course of the voyage. So basically, as I have talked about the arguments and the questions in the Great China Metal Industries and Malaysian international shipping faced, some of them were actually sorted by the courts, and some were still going on. Either I can say it was all pending. So we have just the questions still going on with the courts. Is it still on pending or not? So this is the facts and this is the arguments and questions. So I want my friend Amber to conclude the presentation as well as the rest of the part of the assignment.
Thank you. So my friends, as mentioned previously, they have discussed different facts of the case and some conflicts that exist in the case. Now I'm going to say why we studied in this case and do a conclusion generally. This case is very important as pronounced by the Australian High Court law because for the first time, the Hague and Visby rules were interrupted internationally. Previously, there also have been many cases in different cases where the similar provisions of the law were taken into account. However, this is the first time in Australian High Court that the exceptions of the Hague and Visby rules were considered, and the valuable opinions of the judge were taken into account to understand the exceptions to arise when a ship has to face bad weathers. This case also talks about the system of liabilities and who should be responsible when the damage and loss occur, and how far the cargo owners can reach when they fail to reach the destinations as has been decided manually between different parties. According to TOT 2015-5, so there's a standard of safety principles that should be taken into account by cargo owners. It's essential to point out that there can be no universal items exist to act in certain behavior. They have to take proper precautions and also exercise to their duties. The exceptions of the art of the god of the sea can only be taken when the cargo owners can say they have been very careful in their activities. So that's basically pretty much our presentations from our group. Thank you very much.